Ignition interlock in DUI cases is required only if a person has been convicted of high BAC or operating while intoxicated with a BAC of 0.17 or greater. However, it can also be ordered by a judge as a condition of bond or probation, and increasingly is being ordered by judges for people on probation. So to be clear, if you've been charged with high BAC, that doesn't necessarily mean you're going to be pleading guilty or found guilty of that. If you hire a good DUI lawyer, in fact, like me, there's a good chance you can avoid that and thereby avoid ever having to use an ignition interlock. However, even then, a judge can feel free to require you to drive on an ignition interlock for any part of the time you're on probation. Some judges, for example, require people to drive on it for the first 30 days or 60 days. Another judge could decide that your entire 1 or 2 years on probation should be spent with you on an ignition interlock. But as a legal requirement, only high BAC cases. That said, it's still less common for judges to do that as we sit here now. Over the coming years, however, as we move into 2020 and 2022 and 2025, I think you can expect to see ignition interlocks being used more and more frequently.